This is case number 21-171-517. This is O2 Pharmacy versus City of Detroit. Your appearance at this time for the plaintiff, please. Plaintiff on O2 Pharmacy.
Your Honor, Gregory Patterson here for defendant, City of Detroit. Plaintiff's counsel actually reached out to me and offered to stipulate to a dismissal without prejudice. I did not receive confirmation that they had submitted the order, but if the court would like, I can pull up the email just to confirm that that was our agreement.
All right. Well, based upon the representations of counsel as set forth on this record, I will grant the dismissal of this matter, given that there has been some indication from the plaintiff that they should not proceed with this matter. All right, so I'll sign the order consistent therewith. And if you will, Mr. Patterson, just put your P number on the record.
Yes, Your Honor. Gregory Patterson, P75963 here on behalf of defendant, City of Detroit. And Your Honor, just for the record, I believe plaintiff's counsel was submitting a stipulated order. I don't believe it's been received. So I will keep an eye out for that and put a notation that if it's not received within a week, I'll follow up with them.
Very well, very well. I'll note the file accordingly and we'll indicate that it is pending dismissal under the circumstances as set. Thank you, counsel.
Thank you very much, Your Honor.
The court now calls case number 21-173-316. This is Bright Financial Services versus Katrina Coffin. The matter is before the court set on for a hearing. The court did receive an answer to the complaint that was filed in this matter and set the matter on for a status conference, perhaps a scheduling conference as well. Your appearance for the plaintiff, Bright Financial, please.
Good morning, Your Honor. Robert Goodman. My P number is 55670 on behalf of the plaintiff.
Thank you, Mr. Goodman, and good morning to you. I'm looking now for Katrina Coffin. If you're on the Zoom, please say something at this time.
Hi, my name is Katrina Coffin.
All right, good morning to you, Ms. Coffin. Welcome to this hearing. I have received a document that you submitted as a response to the summons and complaint in this matter. I noticed that the two of you had an opportunity to talk in the breakout room. Mr. Goodman, update me at this time, sir.
Yes, Judge. We have the matter worked out, Judge. Ms. Coffin has provided me with her email address. I'm going to email her a consent judgment with a resolution amount of $2,886. The defendant is going to pay $100 a month on the 30th of each month, commencing May 30th, 2022. And I will get that document to her today. She has some family matters going on, but she will get it back to me within a week, I would think, and then we'll submit it to the court for entry.
All right. And Ms. Coffin, is this in fact the agreement that you've reached regarding the amount and the repayment plan in this matter?
Yes.
All right. So here's what I want to get at. I want to kind of move this forward. I think the first payment on this would be due, what is that, May
30th, 2022.
All right, and how much would the monthly payments be?
$100 each month.
So, ma'am, the agreement is that $100 a month, beginning on May the 30th. If the plaintiff submits a consent judgment document with that language in it, would you have any objection to the court going ahead and signing that? In other words, if that's the agreement, and if he submits something to me with that agreement on it, you wouldn't have any objection to the court going ahead and signing that, and then the thing would commence on May 3rd.
I don't have any objections.
Okay. All right. So what I'm going to have counsel to do, he's going to send you a copy, but I'm going to have him go ahead and put initials for you on the document. And when you put your initials, it's going to be based on an agreement in open court, because I've had a chance to talk. And then I will sign that document. And when you get it, it'll already be signed by the court. It will have exactly what the two of you talked about. If for any reason, somehow something gets in there that you didn't think should be in there, then what you do is come back on the Zoom any day, Monday through Friday, use the same number, come back in and say, "Judge, there's something here that I didn't agree to." We'll get it straight, okay?
All right, that's fine.
All right, so counsel, to the court, I'm gonna give you an email address, so you can go ahead and get that taken care of and send it to the court. And,
I'm ready, Judge.
All right, that's Latifa, Latiff, last name is Hunter, Latifa.Hunter at 36 District Court.org.
Thank you, Judge. I will get that to the court today.
All right, and Ms. Coffey will get that out to you right away, and it shouldn't be any problem. It should be exactly what the agreement calls for. And again, if something crazy happens and you see something that shouldn't be there, then just come back on the Zoom Monday through Friday and let me know that you hear about a case that you settled, that there's something wrong with the agreement. We'll find out what's going on. Okay?
Thank you.
Thank you, Judge.
Thank you, Counsel. Good day to you.
Yeah.
All right, this is case number 21150003. This is Comprehensive Care Pain Management PC versus City of Detroit. Matters before the court. Looks like I do have a motion for summary disposition. All right, your appearance for the plaintiff regarding this matter. I'm looking for a comprehensive care plaintiff. All right, counsel for the city of Detroit, go ahead and enter your appearance if you will at this time.
Good morning again, Your Honor. Gregory Pattison, P75963, here on behalf of the defendant, City of Detroit. Your Honor, I would note that I believe this matter was set for 10 a.m. And so I think it may be best just to pass on this for a moment to allow plaintiff a few minutes of courtesy time.
All right, our notice on this matter says 9:45. That's why I caught it. But we can wait a few moments. I'll certainly recall it shortly.
Thank you, Your Honor.
Mr. Ferguson, which matter are you on? I know it's set for 10 o'clock or so. Which matter is it?
Please unmute, Judge.
All right.
I'm sorry, Your Honor. Case Affiliated Diagnostic versus City of Detroit, case number 20-164661.
Got it. Thank you, sir. This is case number 21-64661. This is Affiliated Diagnostic Coleman versus City of Detroit. The matter is before the court, set for review on today's date or for motion. I know that it's been before me a couple of times. Your appearance for the plaintiff regarding this matter, counsel.
Good morning again, Your Honor. Michael Furtestrom for the plaintiff, bar number 48864.
Thank you, counsel, and thank you for your assistance in this regard. For the City of Detroit, your appearance at this time, sir.
Good morning, Your Honor. Good morning, Your Honor. Alfred Asher on behalf of defendant City of Detroit, P82536.
All right, thank you, Mr. Ashu, and good morning to you as well, sir. So I see that it's a couple of things here. I know that I've had it up for review before.
If I may, I can just update the court on where we are. Initially, I intended to file a motion based on the 1 year back rule, and subsequently learned information that would not allow me to make that argument in good faith before the court. So I did not file that motion. And I let plaintiff's counsel know that I wouldn't be moving forward with that motion as well. And there is another counsel who's the I guess lead counsel, Jamie Lowe or Jordan Dollar. We've engaged in some settlement talks to see if we can resolve this case. We haven't reached a resolution yet, but we are continuing to engage in those talks. And that's where we are with this case.
And Mr. Bergeron, to the best of your knowledge, that's what your understanding is in this matter as well, sir.
Yes, Your Honor. We have a couple of cases regarding Mr. Lott, and I know Mr. Ashu and my office have been working to try to resolve all of them if possible, including this one, of course.
All right, got you. Yeah, this one is a 2020 case, so I'm kind of interested to see that it goes somewhere one way or the other. So I'll go ahead. If I put it out, I don't think it's much of if I put it out for another 30 days. It looks like there's some engagement already. So let me take another look at it at that time. So I'll continue it and find good cause for doing so. City council has indicated that they were going to file a motion. That was a notation that I had, and gave the reasons as to why that was not done on further investigation. So I'll go ahead and find good cause for the adjournment for May 6th.
10th.
May 10th, May 10th, 2022. And that's going to be at 9:45 a.m. May 10th, 2022, 9:45 a.m. Matters continued and set for review.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Good day to the two of you. I have case number 22-14-0039. This is Blaze Medical Solutions LLC versus City of Detroit. The matter is before the court, except for a status conference scheduling conference. Your appearance for the plaintiff regarding this matter, please.
Good morning, Your Honor. For the record, William Saloom, P41487, appearing on behalf of plaintiff for attorney of record, Elias Mawad.
Thank you, counsel. Good morning to you. For the City of Detroit, do I have an appearance on this matter? Know that the answer was filed by Ms. Patricia Porter.
Your Honor, if the court would like, I could run over to her office and see if she's in or try and get a hold of her.
Yeah, let's take a moment to see if we can do that, counsel. I appreciate it.
Thank you very much, Your Honor. I'll be right back. Your Honor, Ms. Porter is working from home today. I have her secretary reaching out to her on her cell phone, so I would expect her to be on shortly.
All right, thank you.
Yeah, Your Honor, I would have no objection to another attorney standing in this for if that's something that they're comfortable doing.
I have no idea what the case is or what's going on. I mean, I'd have to do it.
I mean, it's first time up, and I'm assuming you'll want a discovery period, but I don't want to put you on the spot if you're not comfortable doing so.
If it's just a status conference, I think I can handle it, but it's.
Yeah, that's what it is, and my inclination here is to formally allow discovery over a period of 60 days, and then to review it at the end of that period. I'll allow discovery to remain open to the date that I'm going to give you. Also, I allow for the filing of motions to be set on the hearing date for on the next hearing date, which will be treated as a pretrial conference. That date's going to be June 9th, 2022. And that's going to be at 9:45 p.m., June 9th, 2022. So discovery will be open through June 9th. Any motions may be filed by either party and set the hearing on that date as well. The only requirement will be that any motions filed must allow the other side to have at least 10 days to respond. And if the other side is allowed that 10 days to respond, I'll hear the motion on the 9th of June. This order does not preclude perhaps the filing of motions after that date. It's just that it is convenient for either parties to file it and get it heard on the 9th, and they will have the opportunity to do that. That can be dispositive or not dispositive. And I'll address any other issues with regard to the scheduling in this case on the 9th of June, 2022. Discovery is now over.
Thank you. And Your Honor, could I get that case number one more time just so I can send it to Ms. Porter?
22-14-0039.
Thank you, Your Honor. Will the court mail out the scheduling order?
We'll receive a scheduling order from the court.
Thank you very much. Have a good day, Judge. Mr. Patterson, have a good day.
Thank you. You as well.
Mr. Patterson, perhaps you want to see if you could reach out to the other side on this case.
Yeah.
On the stuff that's 0003.
Yes, Your Honor, I will do that right now.
All right, thank you. We are on the record in 21-15-0003. That's comprehensive care pain management versus City of Detroit. Matters before the court, and I actually had it scheduled for a motion for summary disposition. I know that I previously set a scheduling order in this case, and the parties came back in March, and then the matter was settled before today's date. Your appearance for us for plaintiff in this matter.
Good morning, Judge Zach Katz on behalf of the plaintiff.
And Mr. Katz, your P number, if you will, for the record, sir.
P78426.
All right, thank you, Counselor. Good morning to you. Mr. Patterson, your appearance on this matter, please, sir.
Good morning, Your Honor. Gregory Pattison, P75963, here on behalf of defendant, City of Detroit.
All right, thank you, Counselor. And of course, good morning to you as well, sir. All right, so I see the motion. I'm looking to see whether there has been a written response to the motion. Can you tell me if that's the case, Mr. Katz?
Yes, we did respond to it. I hand delivered it to the court. You should have a copy.
Yes, Your Honor, and to support Mr. Katz there, the register of actions I'm looking at right now indicates that it was filed on March 29th.
And I do have, well, yeah, I do have plaintiff's response. Got it. All right, Mr. Patterson, why don't you go ahead with the argument on your motion, if you will, sir?
Yes, Your Honor, and I'll try and keep this relatively succinct. This is a no-fault provider case for services that were allegedly provided to Mr. Anthony Richardson following a motor vehicle accident occurring on May 15th of 2018. Mr. Richardson subsequently filed his own action in Wayne County Circuit Court. Several providers intervened in that case. We ended up going to facilitation in that matter on November 6th. And we resolved the case with all the intervening plaintiffs there, as well as Mr. Richardson on, let's see here, January 20th. I would note that in the claims file that we received and all the documents received during discovery in that case, we had no indication that there was an assignment relative to the services provided by Comprehensive Care. Of course, as any settlement with the City of Detroit, that settlement was subject to City Council approval, which occurred on February 16th of 2021. The following day, February 17th, the complaint in this action was filed, but it was actually filed over, I believe, in 37th District Court. I could double check that, but it was not subsequently transferred to this court. The city was not then served until February 23rd, and eventually on April 2nd, Mr. Richardson signed the release. During discovery in this case, we requested that plaintiff provide us with any and all documented evidence that they put the city on notice that Mr. Richardson had executed the assignment. We received no response to that, no material response to that, and hence plaintiff has failed to provide any notice or any evidence the city was on notice that they had an independent claim aside from Mr. Richardson. Plaintiff's response, and I assume the court has not had an opportunity to review it, but effectively argues that pursuant to MCR 2.507G, that a settlement needs to be made in writing. However, if you look at some of the case law, for example, Coleman versus Domino's Pizza, the citation is 273 Mish App 449. It's a 2005 case. The specific page number is 459 and it's head note 26. That demonstrates that settlement discussions can be binding and made through email, provided that there is a identifier of the attorney in the emails. If you look at Defendant's Exhibit J, you'll see that the email exchange between plaintiff's counsel in the prior matter and myself both identify the attorney's names. So that would be a binding agreement subject to city council approval, which occurred prior to the filing of this action. From there, we look at MCL 500.3112, which states that a insurer, such as the city, for example, that makes payments in good faith is absolved of liability for bills that may have been assigned unless the claimant or the assigning party puts the defendant on notice that the claims had been assigned. That did not happen in this case, and therefore, pursuant to MCL 500.3112, the city's liabilities were discharged with the settlement with Mr. Richardson.
All All right, Mr. Katz, the city seems to make the argument that they entered into a good faith settlement and that they had no notice, and that pursuant to MCL 500-3112, that this claim is precluded because of that lack of notice and the good faith. So go ahead, Council.
Right. Well, Judge, they were served with the complaint in this case on February 23rd. That was 2 months before they signed the settlement agreement. You know, defense mentions that they didn't know that there was an assignment, but an assignment is not necessary for a medical provider to have its own cause of action. MCL 500-3112 gives the medical provider that authority, that cause of action, an independent cause of action. But they, at any rate, they had notice of this lawsuit on February 23rd, 2 months before the settlement agreement was signed. You know, when they agreed on numbers in January, they didn't have authority to do that because, as Mr. Patterson admits, every settlement is subject to city council approval. City council didn't approve this until February. So there was no writing at the time. There was no writing until April when Mr. Patterson or the city of Detroit had any authority to settle this lawsuit.
Your Honor, if I may respond very briefly.
Yes.
I respectfully believe Mr. Katz is conflating the settlement with the execution of the release. He is correct that I cannot bind the city without city council approval. However, city council approval occurred on February 16th. At that point, the only condition precedent to the settlement was status. That would be, and I've actually run into this in other cases where the case is settled and the plaintiff, for whatever reason, is refusing to execute a release. The court has repeatedly found that once city council approves a settlement, it is a binding settlement. So at that point, the settlement occurred prior to the complaint being filed and 7 days before the city was served. So when the release is actually executed, it has no bearing on the binding nature of the settlement itself. And separately, we're not disputing that plaintiff would have an independent cause of action. Certainly in any case after June of 2019, that's true. But that doesn't negate the implementation of MCL 500.3112.
Yeah, it does seem that some things are being a bit conflated here. Certainly, there would be an independent cause of action that exists here. It seems to me, then, Mr. Katz, that in fact the city council had in fact approved an arm's length settlement that had been reached by the respective parties prior to the filing of a subsequent cause of action, although independent it may be. Your thoughts on that, sir?
Well, my position is that there was no settlement until April, when the parties put pens to paper, because that's what the settlement requires.
So to the extent, and I know that you argue to the contrary, to the extent that the settlement is memorialized and made executional or executory by the approval of the city council, if that's the case, then your argument will fail because you're relying upon there not actually being an executory settlement until April of 2021, correct?
I'm sorry, Judge. Are you asking me?
Yeah, I was, it's kind of putting you in a little bit of blocks here. It's one or the other. If it seems that your argument hangs on whether or not there is an executory agreement, an enforceable agreement, secondary to the city council's approval of the party's underlying agreement, as opposed to that agreement being only becoming executory on 4/2/21. So it seems to me if that agreement is one that can be executed as of the 16th, of February, then it would seem that your arguments would fail in this case.
Well, they didn't execute it on the 16th. They executed it on in April.
Well, the parties already had an agreement that had to go to city council. City council approved the agreement in February. And someone signed off, parties executed releases subsequent to that time. That's the April time that you're talking about. You're saying that your argument is that it's only April is the only thing the court should be paying attention to here, because that's when releases were signed. That's what you're saying?
Yes, I think that the defense didn't have authority to settle the case. The city didn't settle the case until they didn't have authority to do it until mid February when city council met. And then once city council met, the city of Detroit could have settled the case, which they did on April 3rd, I think.
So the city approved the settlement on the 16th of February, but I understand what you're saying is that that's when releases were signed. Mr. Patterson, to the extent that releases are signed in April, if for the sake of argument that is the, and I understand that there's case law to the contrary of this, but Mr. Katz argues the other side of it. But I want to know what your argument is, that assuming for the sake of argument that April is the settlement point, where it becomes executory, if you will. Does that affect your argument regarding preclusion?
Your Honor, it would to an extent, but I would counter specifically that the execution of the release is not a condition to settlement. It's a condition to the delivery of the check. So in much the same, once a case is settled, we've had, other than not Mr. Katz, we've had attorneys a week after our case is approved by city council, they're filing a motion to compel the settlement check. So the execution of the release is not a term or a condition precedent to settlement. It's a condition that we put on to actually pay out the proceeds. The next inquiry would be then, if we were to use that April 12th date, I don't believe it would change the agreement or the argument, because at that point we had negotiated all of Mr. Richardson's bills. There's nothing to preclude Mr. Katz from pursuing those claims out of the proceeds that were paid to Mr. Richardson.
Thank you. Anything else, Mr. Katz? Of course, you know Mr. Patterson gets the last word. Got anything else?
Nothing further, Judge.
All right. The court has listened to the argument on the motion for summary disposition in this matter, and to the opposition to the motion. After having reviewed the motion, heard the arguments thereon, it does appear that the defendant in this matter has nailed the issue with regard to the fact that there was, in fact, a settlement, and that at the time and point of the settlement in this matter, the city did not have notice of any additional claim. And moreover, the city did act in good faith, reaching the resolution, because it did not have notice of the claim. The good faith requirement is a significant requirement, because obviously persons are in the process of reaching some type of resolution, and may have wind and other claims. They may be compelled to try and reach that resolution to conclude other claims. That does not appear to be a factor in this case. It appears that the city, after making its discovery request and after engaging with the claimant, Anthony Richardson, and other claimants in relationship to the case that was brought in circuit court, that they reached a global resolution based upon all of the parties that they received had any form of notice regarding. And despite the fact that comprehensive could bring an independent claim, where that claim was brought subsequent to the settlement in this matter, that claim would be precluded under MCL 503-112. The argument set forth by the plaintiff in this matter, directed by the defendant in the motion for summary disposition, is adopted by the court, and the court concludes that the motion for summary disposition is granted in this matter, based upon there being no genuine issue of material fact, and also based upon the fact that the that a matter had been previously settled by the parties without there being any additional notice, and where the city did in fact act in good faith. That is my determination. Motion for summary disposition will be granted regarding this claim. So,
Thank you very much, Your Honor. Should I prepare the order or will the court issue one?
yeah, I'll issue the order on this matter.
Thank you very much, Your Honor.
Thank you, Judge.
Thank you. Good day to you.
Good day.
Deborah?